089-0805. This is the prosecutor's motion for pretrial detention. This matter is being conducted virtually. I'm Judge Jeffrey Wilson. Today's date is November the 7th, 2025. I will now take the appearances of counsel.
For the state, AP James W. Brown.
Rochelle Pacheco Rozier on behalf of Mr. Johnston in the booth.
Very good. And Ms. Rozier, can we mark this as your client's first appearance?
Yes, thank you. You can mark the matter complete, Your Honor.
Very good. So based upon that representation, we can mark the first appearance for Mr. Johnston as complete. All right. Counsel, I've had the opportunity to review the complaint warrant, the preliminary law enforcement incident report, the affidavit of probable cause, the public safety assessment that was run on November the 3rd, 2025 at 10:55 a.m. The court has also had the opportunity to review the state's motion for pretrial detention and the state's certification in support of the same. Mr. Brown, anything else the state intends to rely upon for today's hearing?
Nothing further from the state, Your Honor. Thank you.
Ms. Rozier, anything else on behalf of Mr. Johnston?
No, thank you, Your Honor.
All right, so as far as exhibits, S1 will be the complaint warrant packet, affidavit of probable cause, preliminary law enforcement incident report. S2 will be the public safety assessment. Ms. Rozier, does your client challenge probable cause?
Yes, Your Honor, we're going to hold the state to its proofs.
Very good. All right, so Mr. Brown, would you please set forth the facts relied upon to establish probable cause?
Thank you, Your Honor. The female victim, CJ, reported to police that her spouse, defendant Johnston, violated a final restraining order that he have no contact with her. That order is FV 011862-25. That FRO is personally served on defendant on June 19, 2025, at the hearing where the TRO was made final. The victim reported that between September 21 and 22 of 2025, defendant sent over 30 messages to her on Facebook Messenger. Police were able to verify that the restraining order was active and was active at the time of the offense, and were able to observe the messages defendant sent. Thank you.
All right, Ms. Rozier, I'll hear from you on the challenge.
Thank you, Your Honor. While we do not contest the fact that there is a final restraining order, this is a soon-to-be ex-spouse, Your Honor. And while this is a disorderly person's offense at this juncture that we would have no further comment on after today's proceeding, and the discovery that was received by the state does not include anything with regard to any messages on Facebook Messenger. In fact, Your Honor, what it does say is that the victim, who Miss Chelsea, lives in a whole nother jurisdiction. She lives in Oklahoma, Your Honor, and our client lives here in New Jersey, and we have not been provided anything with regard to any contact on Facebook or any other type of social media mechanism. At this point, Your Honor, they are in the throes, if you will, of a divorce. I don't know that Miss Chelsea Johnston is not saying anything and everything she can to be able to shore up her position with regard to that divorce and the custody of their children. I would say to the court that while I certainly understand that the threshold for probable cause is very low, at this point in time, it's my understanding that even the folks in Oklahoma declined to prosecute with regard to Mr. Johnston, and we don't have anything to substantiate other than what she says. And as I've said to the court, because they are in the throes of a divorce, we don't know what it is that she's saying, and it hasn't been provided to the defense. We'd ask the court to consider that there has not been probable cause met by the state in this instance.
Very briefly, Your Honor.
Mr. Brown. Mr. Brown?
Thank you. The Oklahoma court declined to prosecute because the defendant is found here. And this court does have personal jurisdiction over this defendant, no question. And the defendant sent these texts from this jurisdiction. So the court has personal and subject matter jurisdiction without question. Second, as to discovery and the messages, discovery was provided to the public defender's office Wednesday at 6 p.m. in this matter. And the reports therein state that the officers reviewed and saw all 30 Facebook Messenger messages to this defendant, by this defendant.
So for clarification, the only thing presented is the reported victim indicating that he sent her 30 messages.
And showed the messages to police who looked at them.
To police where?
In Oklahoma. The Oklahoma police have worked with the New Jersey police. They've worked together on this. The victim is in Oklahoma, which is why she would go to her local police to report it. The local police provided all that information to the New Jersey police, who initiated the charges because that's where the defendant is found.
Do we know
but the offense, this defendant sent these messages while he was in New Jersey. And just as far as subject matter jurisdiction goes, either the place where the message is sent or received gives jurisdiction to that criminal court.
So she resides in Oklahoma, he resides in New Jersey.
Correct.
They're in the throes of divorce. And do we know if there were certain communications that were permitted between them as far as child parenting time or information in contact with the children? Or
the restraining order, which I'm holding, says no contact. You are prohibited from having any, underscored and in bold as the form does, any oral, written, personal, electronic, or other form of contact or communication with the plaintiff.
Okay. Ms. Rozier, anything else?
Your Honor, the only thing that I would indicate is, while I certainly understand the state's position that the Oklahoma authorities were shown particular evidence, that was not shared, to my understanding. Those were not observed by anyone here in New Jersey. That's number one. But number two, the other thing that I make mention of is that I don't know who initiated the contact. And while I understand, before the state even jumps up and says, I understand that the restraining order is against my client, I don't know whether these messages were even initiated by my client or by the victim that's living in Oklahoma. I don't know if the court is aware of how Facebook Messenger works, but Facebook Messenger only works if the person is invited to respond or invited to communicate. That's the way Facebook Messenger works.
The notion that this victim initiated the conversation is made up out of whole cloth. There's no evidence, there's no statement in any of the reports of anything other than this victim going to the police saying, my ex-husband violated this restraining order. Look at these messages. What can we do about this? The police said, well, we can't charge him here in Oklahoma because he's found in New Jersey. They called police in New Jersey who charged him because that's where he's found. And the police in Oklahoma provided the messages to the police in New Jersey who looked at them. It's in the reports that we provided in discovery.
We acknowledge that,
the court's prepared to decide on the issue. There's a challenge that Mr. Johnson is before the court facing a single count of a disorderly persons offense of contempt of a domestic violence restraining order. It is reported that the victim, who resides in Oklahoma, is in the throes of a divorce with Mr. Johnston, who resides in New Jersey. A domestic violence restraining order was issued on June 19th, 2025, restricting Mr. Johnston from having contact with the reported victim. Reportedly, the victim went to law enforcement in Oklahoma and indicated that on a period between the 21st and 22nd of September of 2025, that Mr. Johnston sent her over 30 messages through her Facebook Messenger. Reportedly, there was some issue as to where these charges should be filed, and it was determined that the charges would be filed against this gentleman here in New Jersey, since this is where he resides. The court has been given no information as to the nature of these contacts or these over 30 messages, who initiated them, or who has had the time to verify them.
Your Honor, I'm loath to interrupt, but can I read you a sentence out of the police report that might allay any concerns?
I'm sorry.
May I read one sentence out of the police report, the New Jersey Franklinville police report that might allay any of the court's concerns?
Let me just finish. That information, was not provided to the court prior to rendering this decision. However, understanding that probable cause is a relatively low standard, as the court has stated numerous times. Probable cause is just a well-grounded suspicion that an offense has been committed and that the defendant committed the offense. So with the respect of probable cause, having reviewed the preliminary law enforcement report and the affidavit of probable cause that's attached to the complaint warrants, and hearing the arguments of counsel, the court finds and concludes that the state here has established probable cause, that Mr. Johnston is an eligible defendant. Specifically, the court finds that probable cause has been found for that single charge to issue. All right, counsel, let's move on to the issue of detention. Looking at the public safety assessment, we have a score of 6 for risk of failure to appear, a 5 for new criminal activity. There's no new violent criminal activity flag, and the recommendation is no release. Mr. Brown, I'll hear from the state on the issue of detention.
Thank you, Your Honor. The PSA properly recommends no release. The risk of danger is demonstrated by the current charges in which defendant violated the TRO prohibiting from having any contact with this victim. That FRO arose out of a physical assault on this victim for which defendant was convicted earlier this year, which reinforces his risk of danger. The broader risk of danger is amplified by defendant's conviction for prowling. Risks of flight and obstruction are demonstrated by defendant's pending charge of false report to police and by his 3 convictions for contempt of DV restraining orders in New Jersey and West Virginia. To be clear, that makes the current offense the 4th time defendant has violated a restraining order. Defendant clearly does not abide by judicial orders, and there's therefore no reason to believe he would comply with any conditions of pretrial release. Indeed, defendant was released in the assault case on level 3 monitoring on June 9, and he accrued 2 violations of monitoring in the short month or 2 it took before that matter was resolved. Reinforcing that, defendant has had 3 failures to appear, 2 of them recent. For these reasons, the state requests the court follow the recommendation of the PSA and detain defendant at pretrial.
Very good. Ms. Rosier, I'll hear from you now on the issue of your client's detention.
Thank you, Your Honor. It is the defense position that the PSA score is overstated. We'd indicate, Your Honor, that the 2 prior failures to appear that the state brings up within the last 2 years, one of which was resolved, the Gloucester County matter was resolved, and the Cumberland matter has the next court date of November 14th. So we do know that he has been appearing with regard to that matter. I would indicate to the court that, as I've said, that they are in the throes of a divorce, Your Honor. It's contentious at this point. He clearly lives in a different jurisdiction than his soon-to-be ex-wife. It's my understanding, Your Honor, that she moved to Oklahoma, that she lived here, they were living here in the state of New Jersey. And it is my further understanding that clearly at this point that he is not a danger to her because of the distance between them. I would also indicate to the court, and as the court has aptly found, that we have no verification of the content of any of these messages, even though we understand that it is a low threshold for probable cause. We don't know what the content of those messages were. It doesn't negate the fact that he did not and should not have had contact, but we don't know what those messages were about, Your Honor. I don't know if it was about anything with regard to their children or anything else. And again, I can't say at this point that they were not initiated by the victim herself to, my words, amplify or add heat to their pending divorce actions. I would indicate to the court that my client has been steadily employed. He works for Powell's Plumbing and Heating. He does have family ties in this area, Your Honor. We believe that there are certainly conditions that the court could impose to ascertain his position here in court, to come to court as directed. We believe that those conditions that can be placed on Mr. Johnston at this point are something that the court should consider and not abide by the recommendation of the PSA. We'd ask the court to consider putting Mr. Johnston on level 2 monitoring for the remainder of these charges.
Mr. Brown, anything else from the state?
Nothing needs to be added, Your Honor. Thank you.
All right. All right. This is the prosecutor's motion for pretrial detention in the matter of State versus David P. Johnston, complaint warrant W 2025-0004889-0805. This gentleman is reportedly 37 years old, residing here in New Jersey. All of his ties are reported to be local. He is employed full-time, gainfully employed, and has been so for some time. It is reported that he is in the throes of divorce with the reported victim in this matter, who does have a final restraining order against him based upon an assault. Looking at the public safety assessment, he is facing this single charge of a disorderly person's offense of contempt of domestic violence restraining order. That will be handled in the family court. Looking at the rest of the PSA, he does have one pending charge at the time of this offense, and that is make false reports out of Cumberland County with a court date of actually next week. He does have a history of 5 disorderly person convictions, 2021, 2023, 2024, 2025. We have wandering, prowling to obtain or sell CDS, simple assault, contempt of domestic violence restraining order ×2, and looks like a protective order violation. So that'd be 3 violations of protective order. He has no prior indictable convictions. The PSA identifies 2 of his disorderly person convictions as prior violent convictions. He has 2 prior failures to appear, most recently in 2025, before that 2024. Before that, there was 1 prior failure to appear in 2021 for a total of 3 prior failures to appear. He has no prior sentences of incarceration. He's not currently on probation or parole, not on pretrial monitoring. He does have the history of this 1 domestic violence restraining order, which was just granted in June of 2025. He has no reported active warrants or active detainers at this time. Based on that information, the public safety assessment gives us a score of 6 for failure to appear, a 5 for new criminal activity. There's no new violent criminal activity flag, with a recommendation of no release. The court will now turn its attention to the triad, starting off with failure to appear. This gentleman does have a history of 3 prior failures to appear, 2021, 2024, and 2025. The court does have some concerns there. However, based upon demographic information presented for this gentleman, with him having all of his ties locally, full-time gainful employment, the court is of the position and finds that the appropriate conditions can be put in place to address any concerns of him being a risk of failure to appear. As to the risk of the safety of this victim, those similarly situated, or the community at large, as to the safety of this victim, there is a restraining order. So it's already been determined that there is some concern for the victim's safety in this matter, as a judge has determined that a filing restraining order is appropriate. As to those similarly situated, it does appear that there have been some contempts of domestic violence restraining orders prior. That would go more to the obstruction. But as to the safety of this victim, understanding now that the victim is located in Oklahoma and Mr. Johnson remains here in New Jersey, that does give the court some leeway, and the court is of the position that the appropriate conditions can be put into place to address any concerns as to the safety of this victim. As to the obstruction of justice, yes, this is a contempt charge. He does have prior convictions for that. However, again, the court is of the position and finds that the appropriate conditions can be put into place to address any of those concerns. So based upon the totality of the circumstances, including Mr. Johnston's criminal history, the court is prepared to deviate from the recommendation of the public safety assessment, finding that the public safety assessment does not accurately reflect the totality of the circumstances before this court. Also, the court has looked, again, very closely at the totality of circumstances, including the facts of the case before the court. The court finds now that the state here has not met its burden. According to the court, finds that the state has not met its burden, showing that there's no amount of monetary bail, non-monetary bail, non-monetary bail conditions of pretrial release or a combination thereof that would reasonably ensure Mr. Johnston's appearance in court when required, the safety of this victim or those similarly situated or a community at large, or that he would not obstruct or attempt to obstruct our criminal justice process. Therefore, detention is denied, and Mr. Johnston, you shall be released. Ms. Rozier, given the totality of the circumstances, he is going to be released on pretrial monitoring level 3, our highest level of monitoring. And Mr. Johnston, I need you to listen closely to your release conditions. All of this information will be included on your release order that's being drafted as we speak. Because you are being released on pretrial monitoring level 3, that means you will be reporting to pretrial monitoring every week. And that will either be in person, that could be by phone, that could be virtually, that will be up to pretrial monitoring, but you will have contact with them and report to them every week. While you're on pretrial monitoring, you must appear for all scheduled court proceedings. The next court proceeding that I have for this matter is actually in family court on November 24th. And it's my understanding, Ms. Rozier, that you will not be representing him in that matter. Is that correct?
That is correct, Your Honor.
So, Mr. Johnson, since that will be taking place in the family court, if you are seeking representation, you will have to make those arrangements on your own. But again, that information will be on your release order. Also, you must immediately notify pretrial services of any change in any of your contact information. You shall not commit any new offenses during this period of release. You shall have no contact with the victim. Understanding that there's already a restraining order in place that says no contact. If for any reason that that matter is dismissed, my no contact order still remains in place, and it will remain in place until the appropriate application is made before me or another judge of the criminal division of the Superior Court. During this time of release, you shall refrain from possessing a firearm, a destructive device, or any other dangerous weapon. You shall refrain from the excessive use of alcohol, any narcotic drug, or any controlled substance, unless you have a prescription from a licensed medical provider. It has been reported that you are gainfully employed full-time. You must maintain that employment, and if at any time you find yourself to be unemployed, you must actively seek employment. If you must notify the court immediately if for any reason you cannot appear in court, and if the reason you cannot appear in court is because you have been arrested or detained in another state or another jurisdiction, you agree to waive all extradition proceedings, not only under the laws of the state of New Jersey, but the laws of the demanding state or jurisdiction. Now, do understand that your failure to appear in court when required, a violation of any of these conditions of release, or a new restraining order, the commission of a new crime, could result in the following consequences: issuance of a warrant for your arrest, revocation of your release, possible detention, increasingly restrictive conditions, or forfeiture of any monetary bail. As indicated, your next court appearance is November 24th, 2025. That will be at the civil courthouse located at 1201 Bacharach Boulevard in Atlantic City, New Jersey, 08401. Ms. Rozier, anything else for this gentleman?
No, thank you, Your Honor.
Anything else from the state?
Nothing further than the state, Your Honor. Thank you.
All right, Mr. Johnson, that is all for today, sir. Good luck to you. You can remove yourself from the booth and have them send the next person in.